Hello everyone, and welcome to this third Q&A session for LawFest 2020, this time on international legal regulation of emissions targets. Before I start and introduce Peter to you, I want to acknowledge the traditional owners and custodians of the land on which we're all physically based today. In my case, I'm at the UTAS campus in Cradle Coast, and I acknowledge the Blair Hicka Hillaplu people of the Burnie region. Peter, I know, is in Hobart. I acknowledge the Muanina people as the traditional owners and custodians of the land on the western side of the Derwent estuary. And wherever you are in the state, we acknowledge the traditional owners and the custodians of the land where you are. Our Tasmanian Aboriginal original inhabitants of the land suffered violent dispossession and yet managed to survive, and we recognise and admire the tremendous resilience of ancestors of today's Aboriginal community. We pay our respects to our elders past, present and emerging of today's Aboriginal community and thank them for maintaining the cultural, linguistic and legal traditions of their people that have inhabited this land and cared for it for millennia. I'm really pleased to welcome Peter Lawrence, Senior Lecturer in International Law. He teaches International Law in first semester this year. Peter also teaches International Environmental Law. He helps out with our International Law Moot Court competition program and is Editor-in-Chief of the University of Tasmania Law Review. Before I ask Pete some questions, I've just got a few housekeeping notes that I need to run through. First of all, for those of you watching in, your microphones, video chat and raised hand function have all been disabled so that we can protect your privacy. But if any issues come up for you, any technical issues, you can communicate with us on the panel through the Q&A function on the toolbar at the bottom of your Zoom screen. We're recording the webinar. We know that not everyone from legal studies classes around the state can be present live for this webinar, so we're recording it, but you won't be recorded or identified in any way. I want to just say thanks to those of you who, through your legal studies teachers, sent in questions to us. We really appreciated getting them, and we're going to try and answer as many of them as we can. So, Peter, the first question I'm keen to ask is from Don College. There are a couple of questions from Don in Devonport. Why should the UN continue to be the main platform for climate change cooperation?
Thank you, Tim, and thanks for the warm introduction. I'm really delighted to be here today, and I'd like to thank all of the students and the help they've received from teachers in putting together terrific questions. So a really amazing range of questions. In terms of the first question, the UN climate meetings have become a massive jamboree involving thousands, not just representatives of states, but also non-government organisations. And with the Paris Agreement, which was negotiated in 2015, there's been increasing calls to question this whole framework. The Paris Agreement, as evident from some of the aspects I touched on in my lecture, the Paris Agreement is seriously flawed in many ways. It's predicted that it won't achieve the required reductions in temperature to keep the planet safe. So increasingly, there have been calls for other approaches. I just want to mention one of these approaches. One of these approaches involves commitments being made at the non-state level. The UN brings together states, but also NGOs trying to influence states. The Paris Agreement is an agreement between states. However, given the inclusion in the Paris Agreement of these non-binding nationally determined contributions, calls have been made to take action at other levels of government. This was emphasised in the lead up to Paris by Arnie Schwarzenegger, as Governor of California at the time, who spearheaded very progressive reforms at reducing emissions in California. And you could say now in both the United States and in Australia that it's more at the state or even municipal local government level that more progressive action is taking place. At Paris itself, there were literally thousands of commitments made by both companies and by the central government units of government to reduce emissions. So that seems a promising development. This still leaves a role for the UN in coordinating these approaches. However, there are problems with this approach as well. One of the problems is accountability for reductions. Only ultimately, we're really stuck in a way with the state-based systems in the sense that only states are in a position to monitor carefully whether commitments to reduce emissions are actually being met. And there's a risk that if the pressure comes off states and they retreat, the risk is we end up with what some call a greenwash, which is, for instance, companies advertising terrific reductions they're making, but not delivering. And so I think that's a reason why my guess is that the UN is going to continue to be the primary forum for coordinating action on climate change, in spite of all the serious flaws that the UN system has, which I think will come out in some of the other questions that we move through.
Thanks, Pete. I just had to unmute myself, sorry. The second question, which you sort of started to touch on in your answer to the first one, but also from a Don College student, how are nation states held accountable for reaching their Paris commitments? What happens when they don't?
Thanks, Tim. Yeah, that's a very good question, and this moves us into one of the serious flaws, I think, in the Paris Agreement. We should distinguish here between the overarching objective of the agreement to see, put simply, to see emissions brought down to zero by 2050. We should distinguish that from, which you could see as a collective sort of target, distinguish that from the individual commitments states make, the so-called nationally determined contributions. Now, what happens if they don't live up to these individual commitments they've made? If you have a look at Article 15 of the Paris Agreement, you'll see it establishes a committee, a non-compliance committee. Now, it's described there as being non-adversarial and non-punitive. Now, what non-punitive means is it's not a committee that's designed to impose sanctions. Sanctions are off the table. Now, you might ask, why on earth is that the case? This seems to be a problem screaming out for tough sanctions. And in other areas of international law, you can find sanctions regimes that actually work. A good example is within the World Trade Organization. There are mandated sanctions in terms of trade sanctions on countries that don't abide by the dispute settlement system rulings. So it's not inevitable that the Paris Agreement didn't include sanctions. But if you ask why didn't they include some proper sanction mechanism? I think, put simply, you could describe this as the glass house effect, if you like. If you're in a glass house, don't throw stones. So the basic thing that came into play here, I think, is that governments were concerned that if they open themselves up for other countries bringing claims against them and sanctions being imposed, this could rebound on them. So if they had the possibility of bringing of initiating or calling for sanctions against another country, then it would rebound and impact their interests. It's interesting too that this mechanism in Article 15 didn't give any role for NGOs, because that's another possibility of holding governments to account, is giving a role to NGOs, and there are non-compliant systems that have a role for NGOs, but they didn't go that direction. So where are we left in terms of accountability? I think the overall situation that has two elements. One of it is in terms of national commitments, NDCs. These are scrutinised by a number of climate change think tanks. So these are research institutions bringing together scientists and other experts. If you click on climate tracker, you'll see a number of these top-level institutions have made comparisons of different countries' commitments, their NDCs, and their climate policies. And so there is a form of accountability through the work that these institutes do. The problem, again, is because these are not backed by state power, by governments, it's a more diffuse type of accountability. I suppose too, and just very briefly, the other type of accountability is accountability for the collective goal of trying to reduce emissions down to zero by 2050. There is some accountability through the Paris Agreement itself. It creates a global stocktake mechanism whereby the overarching success or lack of success in reaching the overarching goal is evaluated periodically, and though again the problem with that is that's only a collective evaluation and not an evaluation in terms of whether individual countries are pulling their weight or not.
Great, thanks very much for the answer, Pete. Another question, third one from Don College, which I think is a really interesting one. What role could the International Court of Justice play in this whole space of holding states accountable for their commitments, their Paris Agreement commitments or others? And one of the follow-up sort of aspects of the question is, for example, Palau has sought an advisory opinion through the General Assembly, or asked the General Assembly to request an advisory opinion of the International Court of Justice. What role do you see for the court potentially, if any?
Yeah, thanks, Tim. I think this is a really interesting possibility. I suppose in terms of the political context, there are some constraints in this. You can ask the question, why would states that have refused to take on in the Paris process binding commitments on climate change, and just why would they then agree to a process that could lead to an ICJ decision that could impose legal obligations on them to reduce emissions? So I think there are political obstacles to this course, especially the larger emitters who want to preserve their sovereignty, including large developing countries that see any limits on their sovereignty as impeding their development. At the same time, Palau and other Pacific Island states that are being hammered by the impacts of climate change would see this possibility as one that could be valuable. Now, I think there are some real positives that could flow from an advisory opinion of the ICJ. Now, the ICJ might be understandably reluctant to make a decision which fleshed out very concrete binding obligations on individual countries to reduce emissions. It might see that as politically difficult. On the other hand, the ICJ could productively, I think, give greater emphasis to the collective objectives of the Paris Agreement, and could use an opinion to reaffirm some of the key principles of international environmental law, including the so-called no harm principle, the obligation not to cause environmental harm to other states, and also the precautionary principle, which the gist of this is where science is uncertain, states shouldn't use that uncertainty to delay action. Now, of course, on climate change, the science is not uncertain, it's crystal clear, but still states are balking at action. So I think there are some real positives that could come out of an ICJ advisory opinion, even though at the end of the day, such an opinion it could further influence the political process, but of course it would be unrealistic to assume that states would magically fall into line and comply with the requirements of such an opinion, particularly given their advisory and recommendatory. They're not binding in themselves, such opinions.
Thanks very much. I can imagine that for Palau and Kiribati and Tuvalu and other very low-lying Pacific Island nation states, this is all an existential threat for them, one that's not, that's not far removed. Their king tides are already causing havoc in their countries. And yeah, nothing to galvanise the mind like the fact that your country might not exist in another 10 or 20 years if ocean levels rise.
I think that on that too, I think, Tim, there's that very factor could lead to interesting arguments being made about self-determination. Yeah. How can all states are accepted as having the right to self-determination. How can you exercise that if your very existence is threatened? And in addition, the right to life under human rights obligations and requirements, that's well established as well. So I think, yeah, that those issues would certainly be pushed, understandably pushed in ways that could be helpful.
Yeah, great. No, don't politise. Shouldn't all just be. We can interact with each other a little bit, but it's fine, totally fine.
No, that's great.
There's another question, this time moving away from Devonport down south to Elizabeth College, just up the road from you in North Hobart. In many of the climate litigation cases against governments, they've relied on having a Bill of Rights or some enshrined commitment that the UNFCCC recommends. How could such a case be brought against the Australian government? I guess this, given the lack of a Bill of Rights or some other sort of legal basis for bringing the case, how could a case be brought against the Australian government to enforce their NDC commitment?
This is a very good question. In my presentation, I mentioned the Urgenda case brought in the Netherlands, which did rely on particular constitutional provisions and linkages to the European Convention on Human Rights. Now, in Australia, at first blush, things look grim in that we don't have federally a Charter of Human Rights. However, we do at the state level in ACT and Victoria, and most recently in Queensland, we have a Human Rights Act which came into force this year. Now, the Queensland example is particularly interesting one because an NGO has brought an action against the Queensland government relying on the Human Rights Act in Queensland, challenging the approval given by the Queensland government for the massive Galileo coal basin mining coal project sponsored by Clive Palmer and his interests. And this is likely to be a really interesting test case that will have ramifications around the world in terms of there's been an explosion the last few years of these types of cases, particularly using human rights instruments. Now, just very briefly, the Queensland model of human rights is a dialogue model. So what that means is even if there's a successful case brought against the Queensland government and that a court finds that there are a breach of, for instance, the right to life because of linkage between climate change emissions that would flow from these massive coal projects. Under the Queensland Act, the court can't declare null and void the approval or any legislation that's linked to the approval processes. What happens is that the the project is then pushed back to Parliament. So Parliament retains ultimate control. On the other hand, there's no doubt that if the Queensland government lost such a case, this would put considerable pressure on the Queensland government. And a really fascinating aspect of the Queensland legislation is that in section 48 of the Act, it says that the Queensland courts should take into account both international law and decisions in other jurisdictions related to human rights. So, this decision, if it is successful, could have flow-on effects. It could have flow-on effects in other parts of Australia, and also it could feed into the development of concepts in other jurisdictions in a really interesting way.
That's great. Thanks very much for the answer. I got a question from Launceston Grammar. So you'll notice the geographic equitable approach with starting in Devonport, heading to Hobart, back up to Lonnie. If a country chooses to make national determined contributions, NDCs, binding, what possible consequence could result or flow from that in terms of the imposition of other countries on demands for the state to meet its NDCs? Again, if they're not being followed or met, I mean, yeah.
Yeah, this is, again, an interesting question. I think part of the answer to this question would depend on how the NDCs were made binding. I've argued in some of my writings that one possibility for strengthening the Paris Agreement would be for progressive countries to get together, enter into a binding treaty-level agreement, which would make their NDCs binding between those countries. And it could do so in a way, these countries could do this without undermining the Paris Agreement architecture, if you like. Now, if that happened and non-compliance still occurred, what happens next would partly depend on the content of that agreement. You could build into an agreement like that some type of arbitration provisions that would allow an arbitral process to be kicked off, with countries agreeing to abide by the results of the arbitrator or the arbitral committee. You could even have a referral of a dispute on compliance to the ICJ. Ultimately, of course, you're still stuck in a way in that there's no global police force. Ultimately, you are dependent on political will in terms of states following through. At the same time, my view is that by making NDCs binding, this would increase the political weight behind them, and it would be a positive step. Really, quite ironically, they were made non-binding to appease the United States in the lead up to the negotiation of the Paris Agreement, and then Donald Trump thumbed his nose at the agreement, which yeah, I won't talk too much about that. There's another question on that, but we might come to that. But so it is. I think an unfortunate flaw of the Paris Agreement that they were never binding in the first place.
Yeah, thanks, Pete. Look, I'm just watching the time. We have to finish. We've got a very hard time finishing deadline of 1:20, so that the next webinar to follow this one can start. So there's two questions on the list, and I'm going to supplement the next one with the one from Jane, who's sent one in on Q&A function. Jane's a teacher of legal studies at Scotch Oakburn. So the next question, which is from a student at the Glenorchy campus of Guildford Young College in down south, asks what was the purpose of changing from specific set targets under Kyoto to each country determining their targets under the Paris Agreement? And Jane's question, which I think you might be able to sort of deal with both at the same time, is about, would it be possible for Australia to use Kyoto credits to meet their 2015 Paris Agreement targets?
Yeah, very quickly, the reason why there was a shift away from the Kyoto framework, partly I think was the absolute nightmare that would have been involved, the impracticality, if you like, of trying to get nearly 200 countries to agree on individual binding targets, so a top-down type model. And I think that was you've got to remember too, Kyoto had these binding targets, but they were only imposed on the wealthy countries, not developing countries. So it was a much smaller group of countries. So I think it's that pragmatic kind of factor that was behind that. My guess in terms of Jane's question, I think it's very unlikely that Australia is permitted to use its Kyoto credits, but I'm not close enough to the negotiations to answer that definitively.
Thanks, Pete. Thanks for trying. We've got 4 minutes. So the final question, also from the Glenorchy campus of Guildford Young, is when the US pulled out of the Paris Agreement, did its obligations previously made change, or did they stay the same? The
quick answer to this, Tim, is that the obligations in the agreement stayed the same. And it's very hard to amend agreements like the Paris Agreement. It's interesting to note that when Paris Agreement was negotiated, the negotiators tried to make the Paris Agreement Trump-proof, if you like. When it was being negotiated, Donald Trump was campaigning. A lot of people thought it was very unlikely that he would ever get in office. But to their credit, the negotiators built into what are usually really boring provisions at the end of agreement about when it enters into force, when it becomes binding for all countries. They incorporated some clever provisions whereby a state could only withdraw from the agreement 3 years after it entered into force. And then there was a further year built in terms of the withdrawal instrument taking effect, the result of which any withdrawal of the US formally would only kick in after the US election in November this year. I think generally you can say scholars argue about this, but my view is that the US withdrawal has seriously undermined efforts on climate change, not just because of the symbolic value, if you like, of being part of the Paris Agreement, given how flexible its commitments are, as we've discussed, but linked to that, the US massively pulled out of capacity building efforts to help developing countries deal with climate change. And they send a message that it's okay for wealthy countries to pull back. So I think it's been a disaster. You'll see the stakes in the US election are incredibly high. Joe Biden and the Democrats are committed to rejoining the Paris Agreement and for the US taking a leadership role again. So I can't make party political comments, but it's a very important election with serious implications.
If you're an American
globally.
citizen, get out there and vote. We need to finish up, right, Pete, but thanks very much again for the terrific pre-recorded presentation, and then now for handling these questions so insightfully and comprehensively. Really appreciate it, and yeah, thanks for your involvement.
Thank you, Tim. I've enjoyed myself.
Pleasure. Bye-bye.
Bye then.